County Court, Law number 2 is in session. The court is in session in cause number 25 CCCR 0354. Case of style of state of Texas versus Don Randall. Let the record reflect that Ms. Randall is present in court with Attorney Wright Kimler, State President, Assistant District Attorney, Attorney Andrew Hibble, and Attorney Shane Hilton. I have before me a motion to rescind GPS as a bond condition that was filed by Attorney Wright Kimler for the defendant. State, are you ready?
State for your own.
Defense, are you ready?
Ready.
Mr. Kimler, you may proceed on your motion.
Your Honor, just ask court to take judicial notice of this file.
Okay. Court will take judicial notice of this file.
Ms. Randall has been admitted to bond in this case. Review of the file will reveal that as a condition of her bond, she was ordered to obtain and maintain a GPS positioning device.
Yes.
Ms. Randall has complied with that and is presently wearing the device and paying the fee to maintain the surveillance and monitoring program. We filed a motion to the court to have that condition rescinded for a number of reasons. First of all, Ms. Randall works for the Beaumont Independent School District and impeding her ability to continue to function in that capacity at the school. It's a source of controversy, I suppose, that she's having aware of that and draws attention to her. Secondly, I would submit to the court that the case does not involve, it's not a family assault, anything involving two people that actually have an ongoing relationship or an ongoing pattern of interaction or violence or something like that. Any kind of relationship that would normally entail the condition of a GPS device to make sure that there was no contact between the defendant and the alleged victim. There's no reason for Ms. Randall to have any contact with this person that's made these allegations against her. They're not a family member. They're not a significant other. There's no emotional attachment or anything that would cause her to want to maintain any type of contact or to go near this person. She doesn't even know the person, doesn't know who he is or anything about him, and is certainly not incentivized to go near him or to have any kind of contact with him. And then looking just as far as, I guess the court could review the probable cause affidavit that's in the court's file, you'll see that other than just the allegations of the alleged victim in this case, and I imagine his wife, other than those allegations, there's no corroboration that Ms. Randall even engaged in this conduct. I think there's a mention of her admitting that she was operating a motor vehicle that matches the description of something that was recorded on camera, but there's no indication that any of the incident that the state's complained of was recorded. There's no firearm that was recovered from Ms. Randall. Ms. Randall didn't make any type of admissions against penal interest that she engaged in the conduct that the state's alleging that she engaged in. So basically, she's been ordered, first of all, she's been charged with criminal offense. It's had to post a bond, it's had to hire an attorney, and now it's had to maintain a GPS device based upon a base allegation of an individual with no corroboration, absolutely no corroboration. She's had to go through all of this. It's imposing a financial hardship on her. It's running her $225 a month to have this device, in addition to her bonding fee, and of course having to hire an attorney. It's imposing a financial burden and imposition on her. And also, since this is a case that we are vigorously contesting, it's going to be a jury trial, that conceivably she could be waiting, over a year, 2 years to get to a trial setting. At $225 a month for 2 years, I mean, the court was easy to see how that could mount up into significant commitment of funds to maintain her freedom while she's contesting these charges. And again, it would be a different situation that if say a firearm had actually been recovered from her, if the state's case was stronger, I suppose, and without really, I guess, adjudicating the merits of just going by the probable cause affidavit. But none of that's there. This is just somebody that's made some allegations against her and is subjected to this. Not even someone she knows or has any kind of relationship with. So I would just ask the court, Ms. Randall's not going to engage in any kind of contact or attempt to engage any kind of contact with this person, that the GPS device is an undue financial burden on her and imposition on her. And it also is causing harmful or I guess embarrassing or harmful consequences to her in her everyday life at her job with the school district as well. So imposing that type of stigma upon her that she's the type of individual that has to have an ankle monitor and function in society. That in itself is a stigma and a punishment. Pending a disposition of the order, just simply based allegations that were made by an individual without any type of corroboration. For those reasons, we ask that it be rescinded.
Okay, Mr. Hill, you may proceed.
Me too. So, that's in response to Mr. Kimler's characterization of the state's case. It, as you can see from the probable cause affidavit, we have the testimony of the complaining witness and the complaining witness's wife. There's cameras tying the suspect vehicle in this case to the events that occurred, and the defendant's own admission that she was driving that vehicle at that time. And the testimony of a complaining witness is enough to carry the burden. You only really need one witness who can establish all the elements. And addressing the concern that the defense has as to this not being an assault family violence case, and the argument that since this isn't a family violence case, that the complaining witness is the only thing that we care about whenever imposing this GPS condition. That is not the case. With alleged conducts of a nature that are violent, that involve fits of rage, it is not uncommon for the court to impose GPS conditions, and this is one of those cases, to protect the community at large. The defense insists that without corroboration, the allegations of the complainant witness and his wife are not enough to sustain this. But in these same family violence cases that I was trying to distinguish this case from, it's often the case that there's only one witness to those offenses without corroboration, let's say. And yet this GPS condition is imposed in those cases commonly in this court. So with that in mind, with the fact that community safety is a chief concern of this court, I believe that the condition should remain.
All right, if the court has any questions of her, I will present Ms. Randall from the court for question. The court wants to ask her anything or clarify anything with her.
Well, I'm not going to get into facts of the case or anything of that nature.
Just as far
But I would ask, you did raise the issue that it may be a financial hardship. So what I can do is, well, Article 1.24 of the Texas Code of Criminal Procedure states that all proceedings and trials should be public. However, case of Lilly versus State, 365 Southwest 3rd 321 state that the right to a public trial is not absolute and may be outweighed by other competing interests, such as the interest in security to ensure that a person get a fair trial and to prevent the disclosure of non-public information. Now, the questions that I have would require her to answer, give answers that's non-public information. And so at this time, Mr. Kimler, are you requesting that this portion of the hearing be closed to the public to prevent the disclosure of non-public information?
I'll defer to the court, Your Honor, if the court wants to do this.
Okay. So the court finds that at this time, the court is going to, well, the court finds that the party seeking the closure has advanced an overriding interest that is likely to be prejudicial to his client. And the court finds that this request is no broader than necessary to protect Ms. Randall's interests. The Court of Others also finds that there have been other reasonable alternatives that have been considered, and the court make these findings. At this time, this portion of the hearing will be closed to the public. And so at this time, what I'm going to do, shut this